Today we are going to discuss a question from the topic Hindu Succession Amendment Act of 2005. The question is, does a daughter have right in parental property? Now let us see what is this amendment of Hindu Succession Amendment Act of 2005. The most important amendment was brought under section 6 of the act, which was made effective from 9th of September 2005. Now, what was the amendment that is so important under this Amendment Act? Now, this amendment has given equal rights to a daughter as that of a son. Before this amendment came, there was no right that a daughter could claim from the property of the father or any ancestral property which belonged to the father or any HUF property. After this amendment, the daughter has now been given an equal right as that of a son from the time of birth as a co-partner in the same manner as the son. It has also given same rights in co-partnery property as she would have had if she had been a son, and she also will be subject to same liabilities as that of a son. So these are the three important points to be remembered for this amendment which has been enacted in the year 2005. There is one exception also which has been carved out, which says that this amendment will not invalidate any disposition or alienation, including any partition or testamentary disposition taken place before 2012-2004, which means that if any partition that has taken place and the division of property has been also approved by the court, then such division or the partition or any alienation or any disposition will not be covered under this Amendment Act of 2005. Now, how is this? What problems did it face when the amendment had come into picture? Let us analyze that. The problem that was faced by the Supreme Court was question that whether amendment is retrospective. What do you mean by retrospective? Retrospective would be whether it would take effect from the effective date or it would be applicable before the effective date of the amendment also. Now, before the amendment, after the amendment had come into picture, there were two conflicting decisions of the Supreme Court of the Division Bench. In one of the decisions held in 2016, the Supreme Court held that living daughters of living co-partners as on the date of the effective amendment, that is 9/9/2005, it would be only on that date whoever is alive, it will apply to them. However, in 2018, another judgment of the Supreme Court came which said, irrespective of the fact whether the father or the daughter is alive on the date of the amendment, by way of birth, the daughter will have a co-partner right, and hence the amendment is retrospective in nature. Now, because there were two conflicting decisions, therefore this matter was referred to a three-judge bench of the Supreme Court, which was headed by Justice Arun Mishra, along with Justice S. Abdul Nazir and Justice M.R. Shah. This question was resolved in the case of Vinita Sharma versus Rakesh Sharma, and the judgment came out in August 2020. What did this judgment held? It upheld the 2018 order and said that the amendment is retrospective in nature, but the partitions which have already taken place before the amendment had come into being, those cannot be reopened. Hence, this verdict made it clear that the amendment to Hindu Succession Act granting equal rights to daughters to inherit the property would have a retrospective effect. It also said the daughter shall remain a co-partner throughout the life, irrespective of whether her father is alive or not on the date of the amendment, that is 9/9/2005. Now, what are the important points that we need to remember when we are looking at this ruling and the amendment? The first important point is that it applies only to HUF property, that is the ancestral property. and not applicable on self-acquired property. So if a father has more of a self-acquired property and has nothing as a ancestral property, then a daughter cannot as a birthright claim partition. It is the prerogative of the father whether to divide the property that is self-acquired between both the children, for example, a daughter and a son, or will it away to anyone or gift it away to anyone. Second important point is a daughter continues to be a co-partner even after the marriage. The question was also resolved in one of the important judgments where the question was whether after the marriage has taken place would still the daughter be a co-partner. The Supreme Court held yes, the daughter will remain a co-partner even after the marriage. Hence, the important point that is now upheld by the Supreme Court is that Section 6 of the amendment which was brought in 2005 will have a retrospective effect, and it will continue. It will also have why a daughter will have a right into the property even after the marriage, and it will apply only to HUF property and does not affect any personal or self-acquired assets which are held individually.